Nice to see you guys again. This is the second time I come up here, and I'm going to talk about the statutory requirement of customer due diligence, what we call CDD, and record-keeping requirements. To start with, let's have a look on the money laundering and terrorist financing threats on TCSPs. According to international topologies, criminals often take advantages of the services provided by TCSPs as well as other service providers and professionals. They help them to set up shell companies or complicated or complex corporate structure to help them obscure the beneficial ownership and help them hide away the proceeds of crimes. And they also help them to develop confusing audit trails to evade action by law enforcement agencies. In Hong Kong, the threat normally stems from the misuse of legal persons and legal arrangements, in particular the misuse of shell companies. Criminals often use shell companies to help them conceal the proceeds of crimes, and in some cases, they even use shell companies for their predicate crimes. They sometimes use the secretarial service providers and trust accounts provided by service providers in their money laundering scheme with a view to enhance the apparent legitimacy of their schemes. To address those threats, it is necessary to require TCSPs to comply with the CDD and record-keeping requirements, and it resulted in the amendments to the AML, which takes effect on the 1st of March, last Thursday. I think many of you are anxious to know to what extent the activities of TCSP licensees are subject to the CDD and record-keeping requirements. Actually, Section 5A of the AML stipulates that if a TCSP licensee prepares for or carries out for a client transactions concerning a trust or company service, then the licensee is required to comply with the CDD and record-keeping requirements. And Section 1 of Part 1 of Schedule 1 to the AML further elaborate on what trust or company service means. It actually means the provision in Hong Kong by a person by way of business of one of the following services to another person. You can see the full details of the 4 elements of trust or company service here. In other words, a licensee is only required to comply with CDD or record-keeping requirements when it's carrying out a trust or company service. If a licensee also carries out other business like investment or trading, then for that part of the business is not required to comply with the CDD and record-keeping requirement. Then, what exactly are licensees supposed to do in performing CDD measure? There are 4 elements in it. Firstly, the licensee are required to identify the customer and verify the customer's identity. Secondly, if there is a beneficial owner in respect of the customer, the licensee have to identify the beneficial owner and take reasonable steps to verify the identity of that beneficial owner. If a business relationship is to be established, the licensee are required to obtain information regarding the purpose and the intended nature of that business relationship. If there is a person purporting to act on behalf of the customer, the licensee has to identify that person and take reasonable steps to verify the identity of that person. Then, when a licensee is required to carry out CDD, there are 4 situations that a licensee must carry out a CDD. First, before establishing a business relationship with a customer, or before carrying out an occasional transaction of which the amount exceeds 120,000 Hong Kong dollar. Or in case if the licensee has suspicions that the customer or the customer's account is involved in money laundering or terrorist financing, then the licensee has to conduct CDD. Or in case the licensee have doubt on the veracity or adequacy of the information obtained in respect of the customer or the beneficial owner, then the licensee must carry out CDD. Licensee must note that if it cannot complete the CDD process, it must not establish a business relationship with the customer. Or in case it has already established a business relationship with that customer, it has to terminate the business relationship as soon as reasonably practicable. But having said that, under certain special or exceptional circumstances where it is necessary not to disrupt the normal conduct of business of the customer, and all the money laundering and terrorist financing risk has been effectively managed, then under that exceptional circumstances, the licensee may establish business relationship with that customer and thereafter, as soon as possible, complete the verification of the identity of the customer. I understand that many practitioners are very concerned about the, what we call it, pre-existing customers. There's those customers who are on board before the commencement of the licensing regime. In fact, licensees need not go through the CDD in respect of all these pre-existing customers over again, as though they were the new customers. However, if the licensee notes that for that customer, an unusual or suspicious transaction has taken place, or there's a transaction which is not consistent with the licensee's knowledge of that customer or the customer's risk profile, or the licensee notes that there is a material change in the way that the customer's account is being operated, then the licensee is still required to conduct CDD in respect of that pre-existing customer. If the licensee cannot complete the CDD requirement and measures, it has to terminate the business relationship with that pre-existing customer. Please be reminded that licensees are also required by the AML to continuously monitor their business relationship with the customers. As such, a licensee are required to review from time to time the document, data, and information relating to the customer obtained during the CDD process to ensure that all those information are up to date and relevant. They are also required to monitor the transaction of the customer to ensure that those transactions are consistent with their knowledge of the customer's nature of business and risk profile, and as well as the source of funds. Licensees are also required to identify transactions that are complex, large, or unusual, or for those transactions which have no apparent economic or lawful purposes. They are required to examine the background and purposes of those transactions and note down their findings in writing. We have talked about the basic element of CDD AML also requires licensees under certain circumstances to take enhanced measures to identify the customer. They will call the enhanced due diligence or EDD. The first of those situations is where the customer has not been physically present for identification purposes. Under that situation, licensees should further verify the customer's identities on the basis of information or document that they have obtained earlier but had not been used for identify the identity of that customer. Or it may take supplementary measures to verify all the information provided by the customers, or it can assure that the first payment made to the customer's account are received from an account in the name of the customer opened with an authorized institution, usually a bank, or a financial institution operating in an equivalent jurisdiction, and that institution are also subject to similar CDD or record-keeping requirements. The second situation is where the customer or the beneficial owner of the customer is a politically exposed person. If you note that the customer or beneficial owner of a customer is a PEP, before establishing business relationship or continue with the business relationship, staff of the licensee has to obtain senior management approval. And the licensee have to take reasonable measures to establish the customer's or the beneficial owner's source of wealth and the source of fund of the business. Section 1 of Schedule 2 to the AML gives you a very detailed definition of what PEP means. But in GITS, it means an individual who is or has been entrusted with a prominent public function in a place outside the People's Republic of China, including the person's spouse, partner, child, parent, or close associate. You may refer to the detailed definition set out in Section 1 of Schedule 2. There are also other high-risk situations that special requirements to CDD measure are required. For instance, where the customer is a corporation which has issued bearer shares, or the customer is coming from, or the transaction is connected with a jurisdiction that had not implemented or had not adequately implemented the recommendation of FedF, or where the situation is a high-risk situation specified by the registrar in a notice given to the licensee. Under those high-risk situations, staff of the licensee should obtain approval from senior management, and either the licensee should take reasonable measure to establish the customer's or the customer's beneficial owner's source of wealth and source of fund, or take additional measures to mitigate the risk of money laundering and terrorist financing involved. Regarding the ongoing monitoring of the business relationship regarding those high-risk situations that I have just mentioned, licensees are required to take additional steps and measures to compensate for the money laundering or terrorist financing risk involved in their business relationship with those high-risk customers. There are also situations that licensee is allowed to take simplified CDD measure against the customer where the customer is within the definition of the category under Section 4 of Schedule 2, or the transaction belongs to those specified products or services defined in Section 4 of Schedule 2. You may refer to the detail of different categories of customers and product in that section. The difference between simplified CDD and CDD is that under SDD, the licensee is not required to verify the identity of beneficial owners of the customer. That's the only difference between SDD and CDD. I think you should bear in mind the difference when you conduct CDD or SDD. Please note that AML also allows licensees to conduct CDD by means of intermediaries. However, all licensees must note that although they can rely on intermediaries to do the work, but the ultimate liability and responsibility still remains with the licensees themselves. You may see here those intermediaries that you are allowed to perform CDD on behalf of licensee. They are all under regulation in respect of anti-money laundering and counter-terrorist financing regimes. For those intermediaries that are allowed for use in an equivalent jurisdiction, they are also under the registration, licensing, or regulatory regime of that jurisdiction and are subject to the same or similar CDD or record-keeping requirements as their local counterparts. Now let's move on to record-keeping. The essence is that you are required to keep, in respect of a transaction, at least 5 years of those records after the completion of the transaction. And for a customer, you have to maintain and keep those records for at least 5 years after the end of the business relationship. So you must be eager to know what records are supposed to be kept. For a transaction, the records are the original or a copy of the document and a record of the data and the information obtained in connection with that transaction. And in respect of a customer, the original or a copy of the documents and a record of the data and information obtained in the course of identifying or verifying the identity of the customer and beneficial owner. And those records related to the original or a copy of the files relating to the customer's account and business correspondence with the customer and the customer's beneficial owner. If a licensee failed to comply with this CDD and record-keeping requirement, the licensee will be subject to the disciplinary action of the registrar. For that, we have covered it in detail in our previous presentation, so I'm not going to cover it in my presentation here. For your information, the registrar had published in the Gazette on the 9th of February the guidelines on compliance of anti-money laundering and counter-terrorist financing requirements for TCSPs. In that guideline, it provides guidance in relation to the operation of the provision of Schedule 2 to the AML. It also provides references to financial sanction, staff training, risk assessment, reporting of suspicious transactions to JFIU. So I will take this opportunity to recommend all of you to familiarize yourself with the content of that guidelines. For that, this is the end of my presentation. Thank you.